Yes, I'm so sorry. It's took some time to get the post. Yeah, today's class we are going to discuss about a memorandum of association, articles of association, and prospectus. Memorandum of association and articles of association uh, is about under the incorporation of a company. So let us start. Okay, I'm sharing screen here. Incorporation of a company. Incorporation of a company, generally, a company under the formation of a company, we have seen involves four stages. That is, formation of a company involves four stages. The four stages are that where a company involves promotion, incorporation, raising of capital, and commencement of business. Generally, for a private limited company, promotion and incorporation are only the two stages. Once they get the incorporation of certificate of incorporation, they can start their business. Okay, but public limited companies has to wait for raising their capital and get a one more certificate called certificate of commencement of business. Okay. Mm. Yeah, practicals, only university knows children. Concentrate on class first, then we can discuss about the practicals. And practicals about practicals, only university can tell. So let us concentrate on today's class. So now, under the incorporation of a company, we are going to discuss about the important documents to be submitted by the, important documents to be submitted by the company. Um, So, incorporation of a company means registration of a company. A company, in order to get registered, involves so many legal formalities, and these legal formalities generally are required to be followed by both the private and public limited companies. A private limited company, in order to get registered, means both companies need to be get registered, which is must for both public and private limited companies. Okay. So generally, registration of a company as per Companies Act rule is compulsory, right? A company need to get registered as per the Companies Act rule. Uh, how do they get registered and what are the documents to be followed? That there's certain important documents, the promoters of company, whoever are there, they need to fill a certain important documents in order to get the company registered. So what are those? There's both the public limited company and private limited companies are required to get a registration and fill these documents: memorandum of association, articles of association, list of directors, written consent, and the people who are agreed to work for the list of directors, written consent, and written consent of the directors to act as a directors of the company, and also statutory declaration, that is association. So again, under this each document, it is necessary to see what are the formalities and what is the information provided in these documents is what we are going to discuss under these documents. So generally, incorporation. If a company is a private limited company, it need to mention it's a private limited. If it is a public limited company, it need to mention as a public limited company. But both the companies must go for a registration or incorporation of a company. So for that, the first document that you submitted is memorandum of association. What is memorandum? Means originally framed by the company, and this is the document. It's a fundamental document of the company, based on which it tells the powers of a company in relation to the outsider world. Means what are the powers of a company, and what are its relationship, what relationship it is going to maintain with the public, being a company, are defined under this memorandum of association. Okay, so why do they prepare? The very purpose of the document is to inform, that is to enable the shareholders, whoever the investors, creditors, and those who deal with the company, to know it's a permitted range of activities. Okay, like within what range a company is going to perform its activities. To inform about that, a company generally will publish this memorandum of association. Means it is required, because see, companies are raising their capital from the public, and their public interest is involved in that. So being an investor, before investment, an investor would like to know or the basic information relating to the company. So such basic information, whatever is there, is provided under this document called memorandum of association, and based on which the company is going to perform its functions. So it is called as the fundamental document of the company. So if you look into the Companies Act 2013, Section 2 of 56, memorandum means it's a memorandum of association of a company is originally framed and altered from time to time in pursuance of any previous law of this act. Okay, so when a document which is framed by following the Companies Act, and if required time to time, which is goes into alterations, that document we call as a memorandum of association. This is the first document and the foremost document and the fundamental document of the company at the time of formation of a company. And so it's a constitution. It set out the constitution of the company, and the company, based on this, you can say what is the structure of the company, how it's going to function. Okay, that is the reason we also called not only a fundamental document of the company, but also charter of the company, like how a pillar is main for the construction of a building. Okay, same way, this document is like a pillar on which the company stands out. Okay, that is the reason this document has the utmost importance. But when this document, whatever they prepared, this document when preparing need to be printed. This document is to be printed and divided into paragraphs numbered consecutively. Okay, means it should be in a printing. It should be divided. What the matter in the document, whatever the information is providing in this document, has to be divided into different paragraphs if necessary, and those paragraphs has to be given numbers. Okay, and after that, this document also has to be signed by 2 subscribers if it is a private company, and 7 in case of a public limited company, one in case of a one-person company. So I told you in the latest Companies Act 2013, there came into existence one more company, that is one-person company. So in case of one-person company, one person has to sign. If it is a private, to subscribers means the people who involved in preparation of this memorandum of association, this document, or those subscribers, we'd say them as the subscribers, and at least minimum two people, two people has to sign. That is the directors in case of private company, and 7 in case of public limited company has to sign. Now, if you look into the what is the information this document provides, what is such important information this document provides to the public about the company. If you look into that, these are the contents of the memorandum of association. So, what is that? First, name of the company. The next, state in which the registered office of the company is situated, and the objects of a company, liability of members, share capital of the company, and agreement among the members of the company. So these are the clauses or the contents of the memorandum, which is important to remember. So first clause, name clause. What does the name clause says? Under this clause, see, these are the contents under which, depending on the company to company, the information changes. Okay, name clause tells about the name of the company, that company. Okay, these are the main contents. Every company's memorandum of association will be there, and inside the information inside the each content of the clause changes according to that company. So let us see what are the rules or the points to be observed, legal provisions to be followed while mentioning the name of the company by the companies while preparing their memorandum of association. So a company, when preparing their memorandum of association, first under the name clause will give its name. What is that company's name? Okay, what the company name, how it is going to, what is the name of the company, and nature of business. These are the important to be provided, information to be provided by the company when it is giving in name clause. Under the name clause, name of the company, simple. Name clause tells about the name of the company and nature of the business. And not only that, every company will have its own logo, or it has its own logo or symbol. See, I think I didn't give the pictures. Okay, every company has its own name and logo. See, if you see a big M, you will say McDonald. If you see right mark, you will say it is Nike. And if you say a running cheetah, you will say it's a Puma, right? So that means every company, in order to get easy identification by the public, will also have its own logo or a symbol for the identification of its corporate existence. So company, under the name clause, a company gives about name of the company and nature of the business, and also the logo or symbol of the corporate existence. But okay, but at the same time, every company should remember, under while selecting their name or logo, they should remember that their name or the logo should not be similar to or identical to the existing company. The name of the company or logo of the company should not be similar to the existing company's name or logos. Okay, and that okay, the provisions of Companies Act says that there should not be similar names and logos of existing companies. And okay, and no company should be registered with that name, not to be registered with such name. Coming to that, next one. Yes, name of company shall not contain any of the words or phrase that a central government or state government or local authority like that. Okay, if it is a public limited company, simply at the end of the name of company, limited company will has to be there. And if it is a private limited company, so at the end of the name of a company, a private limited term must be there. If it is a one-person company, they should use OPC at the end of the company. OPC means one person company. Okay, these are the things to be remembered. So remember, what is that? First, name clause indicates name of the company, and this name of the company should not be similar. where it indicates name of the company, nature of business, and symbol or logo of the company about corporate existence. Okay, and this name or logo or should not be similar to the other existing company. Second thing is that if a company is a public limited company, at the end of the name, it should mention limited company. If the company is a private limited company, at the end of the name, you should specify private limited. If it is a one-person company, you should specify one-person company at the end of their name. That is to be remembered. Okay. If anyone fails to follow this, they will be punishable. The second clause is registered office clause or situation clause. What is this registered office or situation clause? Means under this clause, company tells where it's a registered office is going to be located. Means where they are going to operate their business activities, where they are going to locate their office relating to their company. That address has to be given, and whatever the address they specified under this situation clause, under the same address it has to continue business operation, like of administrative operations, and on every document that it uses in its business has to be printed with this address. Okay, that's a must. Letter pads or emails or bills or checks, whatever they use for the communication or for transaction purpose, whatever the document for the purpose of business, on the name of business they do, all those documents has to be printed with the address of the register office that they registered with the registrar. Now let us see what are the rules relating to this registered office. Where they can, so where they are supposed to, means it's not only that under this clause they're supposed to give the address of their registered office, that they're also supposed to mention under which jurisdiction it comes. Okay, see, usually if you notice any company advertisement, or not only that, any dealing if you do or enter into any company's transaction, at the end they give a small note. Any legal proceedings will be only under the jurisdiction of the company's registered office. You notice next time. Okay, at the end they mention any legal proceedings only will be and only under company's register office jurisdiction, entertained only under company's register of jurisdiction, means under the which court the register of comes that has to be given. Okay, so address of the registered office and jurisdiction under which they comes. So once they give this address and the location of their office, within the 15 days of incorporation, a company must start its business in that means in start open its administration office in that address. Okay, and even a registrar will go for the verification of that registered office within the 30 days of its incorporation. That means at the time of incorporation, means while going for registration they should give this is the place where, say, in a RP road or Laniganj road, we are going to so and so address, so and so building, we are locating our office, that you mentioned, and it comes under the Secunderabad court purview. You mentioned all these address under course where it comes, and you submitted, you received the incorporation certificate. So once you receive the, if you till you once you receive the incorporation certificate, within the 15 days of the certificate you receive, you're supposed to open your office in that particular address where you what you specified in your memorandum. Okay, and registrar also within the 30 days of issue of that certificate will come for the verification. Means he will send the person to for verification whether in that particular address that office is opened or not. Understood? This is the legal provisions. Okay. And third point, they are supposed to print this registered office address on all its communicative documents or the transactions which it enters into the on the name of company, like a letterheads, bills, invoices, checks, whatever not. The third one is object clause. Yes, this is the important clause which supposed to be prepared with a very care and caution, because this is the clause based on which the investor will take his decision whether to invest or not to invest, and how his investments are going to be utilized by the company. So all these what are the permitted range of activities of company, and how the company is going to utilize, what is their objective, and what are their goals, targets, vision, values. All this will be known through this object clause. So object clause has to be prepared with a very care and caution. It tells of the so what the object clause means? It is an important clause, defines the limits and extent of the activities of a company. And actually these objects clause consist of three types. A company consists of generally three types of objects, like primary objectives, secondary objectives, and objectives which are not included under the primary and secondary. Primary means the main mission of the company, whatever vision of the company, whatever. Secondary objectives to achieve that mission, what is the visionary activities, what are the values is going to follow, and other than that, whatever other activities are there, those comes under the third type of objective clause. Okay, and this with this clause, this subscriber, that means investors, will come to know how their investments are going to be put use, and extend the protection to the shareholders by the company. So creditors, investors, people, whoever is going to deal with the company, will come to know the permitted range of activities of a company. The next one is liability clause. Yes, the liability clause is another clause which tells about the liability of members of a company. You may get a thought, madam, in functions you said liability of joint stock company members is limited. Then what else to discuss here? Yes, limited by what? That has to be given, right? So the liability of our members, joint stock company members, is limited, of course. But is it limited by shares or limited by guarantee? That information has to be given, and though it is implied that companies members liability is limited, they must include this information also in the memorandum. So liability clause tells about the liability of members, whether it is limited by shares or limited by guarantee. If it is a limited by shares, means what? The members liability is limited to the face value of the share. Say for example, company's share value is 10 rupees. So the shareholders liability is only to the extent of 10 rupees per share, whatever the number of shares he held into 10. Okay, so what if, say for example, by the time company some reasons is got into losses, and the shareholders has asked to pay for the amount, then generally whatever the unpaid amount, that will be collected. So you remember simply, liability clause tells about the liability of members. What is that? Liability of members is limited. Okay, next, limited by shares or limited by guarantee. Okay, limited by shares means limited to the extent of face value of the shares. Okay, next, second thing is limited by guarantee. Means what? Generally they give some percentage, some guarantee, the amount to be payable on the liabilities of the company. So to the extent of the guarantee that's given by the shareholders or the members, or their liability will be limited. So under this, a company tells about what their members' liability is going to be. The next one is capital clause, again, which is another important clause of the company, based on which a company investors will come forward. The first one is, sorry children, these are not question marks. Actually, I did in MS Office PowerPoint. and when I upload it to Google Drive, they changed the format entirely. I'm sorry, don't get confused about these question marks here. These are bullets actually. Mm. Let us come back to the capital clause. What is the capital clause? The capital clause tells about the amount of share capital of a company. So, what is the actual nominal amount of a company wants to raise? Amount of capital the company wants to raise, and it has to register. It's a nominal capital. If you want to raise, the company has to be registered. Okay, and what I said, company raises capital in the form of shares, dividing into small units. So, how many shares? That entire capital has been divided into how many shares, and what is the value of each share? That information to be provided not only to the registered or registrar, but also the members, investors. Okay, and next, how much amount of capital is going to be raised or issue for the subscription, that also to be given. Next, a company can issue there are different types of shares are there. So it has to inform how many types of shares is going to issue, what are the different types of shares issued, and what are the voting rights that the shares have, and what are the rights of the shareholders by possessing those types of shares. All this information has to be provided in the capital clause. I'll repeat once again. Capital clause tells about the capital, the entire capital of the company, the total capital of the company. The total of capital of the company which is going to be registered is called as authorized capital or nominal capital, beyond which a company cannot raise maximum. Okay, and in that authorized capital, company again issues some different types of shares it can issue. So, how many types of shares it is issuing, and what is the capital totally divided into number of types, and how many shares divided into how many shares issued, and what is the value for each share it fixed. All this information must be provided in the capital clause. Along with that, whatever the different types of shares issued, and what are the voting rights of these shares, or the rights and the duties of these shares holders also to be provided. Right? Now, next one is association clause. What is this association or subscription clause? Generally, these are all the information. How many we have seen? 5. What are they? Name clause, situation clause, objective clause, liability clause, capital clause. Right? So, under these clauses, related information has been provided. Who provide that? Who are the people involved in that? The subscribers, or the people who are the promoters, or the subscribers who are undertaking these incorporation, registration, legal formalities of the company. Those are the people who are preparing this memorandum. So there should be authentication, right? So the subscribers to the memorandum, whoever involved in preparation of memorandum, must signify their willingness to associate with the firm and form a company, and also must subscribe, must give an written consent that they are prepared all the formalities of followed all the provisions of Companies Act with the registration of a company to their knowledge, saying that they should sign on the memorandum under the association clause. Okay, generally, how many people to sign? If it is a private company, at least 2. If it is a public limited company, at least 7, and 1-person company, 1 must sign. And not only these subscribers of the memorandum, but also a witness, a person who stood as a witness, also has to give a attestation, means put his signature. So association clause or subscription clause, what does it mean? It contains in this clause, the subscribers to the memorandum will signify their will give their acceptance and willingness to associate with the firm and form the company, willingness to form the company, And second thing, they stating that all the provisions of Companies Act with regard to incorporation of company has been followed, they will sign. So mentioning these 2 points, these subscribers will put their signatures on the document under this clause. So how many to sign? Means if it is a public company, 7 subscribers to be signed. If it is a private company, 2 subscribers are supposed to sign. If it is a one person company, 1 subscriber. Along with these subscribers, the one person who as a witness signature also must be given. So that's about contents of memorandum. I'll repeat once again: name clause, where name and nature of business and location of the logo of the business will be given. Situation or registered clause, the registered office, where the registered office company has been located has to be mentioned, and at the same address the company has to make their communications further, and it should locate its office within 15 days of the incorporation of a company. Okay, the third one is object clause, which is important, based on which subscribers or the investors, based on which investors will come to know where their investments are going to be put to use by the company, how much security company is giving to their share investments. So it is generally object clause contain 3 types of objectives. The fourth one is liability clause, under which company's liability to members will be mentioned, either limited by liability limited by shares or limited by guarantee. Fifth one is capital clause, in which the capital of the company will be specified, the number of shares divided, value of each share, types of shares, voting rights of shareholders will be mentioned under the capital clause. After all these 5 clauses, information is provided. At the end, the subscribers who are involved in preparation of this memorandum also to be signed in front of a witness. That's the memorandum of association. Let us see alteration. Yes, children. Alteration of memorandum of association is very difficult. Any alteration of these documents involves expensive and time consuming, involves so many rules and regulations. Okay, so they should. That's the reason why we say they need to do it with very care and concern. Next, we don't need that. Yeah. The next clause, next important document at the time of incorporation of a company is articles of association. Yeah, here I would like to tell you, children, if you get a question, write the procedure for incorporation of a company. About these 2 documents, minimum you write. You need not to explain the clauses. Okay, only what is memorandum of association, what clauses it consists. If you write is enough. If you are asked to write about the procedure for incorporation of a company, or what are the important documents to be filed for the incorporation of a company, if you write a brief about memorandum and articles, enough. But if you get a question separately, what is a memorandum of association, what are the clauses in it, then only you are supposed to explain all the clauses in the memorandum of association. Done? Now, okay, now let us proceed to the articles of association. What is an articles of association mean? It is a secondary important document of a company. This articles of association is a secondary important document of a company, and by which a company can as the memorandum of association tells about the powers and activities of the company with the outsider world, whereas in articles of association of a company tells about rules and regulations for the internal management of the company. Articles of association of company tells about the internal management of a company, rules and regulations relating to the internal management of a company. Okay, so sorry. So articles lay down the manner in which objects in memorandum has been mentioned. Okay, these articles to be given whatever is mentioned in the memorandum of association. Now, that is a respective form specified in the Schedule 1 of the Act. Like memorandum of association, even articles of association must be printed, divided into paragraphs, and numbered consecutively. Hmm? The article shall be in signed by the subscriber. So, articles of association is again secondary document, important document, which works under the following the memorandum, whatever given in the memorandum. Under the memorandum of association, uh, it prepares the rules and regulations for the internal management of the company. Okay. So this document guides the means helps the organization and how to conduct the business internally. Okay, and so this document also, under this document, various rules and regulations will be discussed. The contents only will discuss. Under each content, the information differs from company to company. So this document must be in the printed format, and any information required to be divided into paragraphs, and each paragraph has to be given numbers. Okay, and this document to be stamped properly on this, and subscribers of this document also has to sign like in the memorandum along with the witness signature. So let us see the contents of articles of association. It contains document like information like first normal name of the company, nature of the business, location, all that. Apart from that, it tells what is its share capital, and what are the types of shares issued, and what are the rights of the shareholders, what are the variations in the rights of these different types of shareholders will be given. And lien on shares means do shares can be sent or not. Okay. Then calls on shares. Generally, as we mentioned, capital is divided into shares, and each share will be given a value. So, but whatever the share value has been given by the company, that share value generally company will not collect at a time. It collects in installments. Those installments that it collects on is called as a calls. Each installment is called as a calls on shares. Okay. Transfer of shares. What is the right of shareholders in transferring shares from one person to other person? Can do transfer or not? If to transfer, generally shareholders are free to transfer, but still, this transmission of shares. Transmission of shares means transmission means converting is like a or the title transmission of shares is that one person, say for example, the holder of the shares has been died, or he became a insolvent, or he became a what you call mad. Then in such case, what are the rules applied, how they can what is the legal provisions required to be followed to transfer the shares, transmission of shares. Forfeiture of shares. Forfeiture of shares means cancellation of shares. Cancellation of shares. When do company cancel the shares of a shareholder, and what are the rights held by the company in order to cancel the shares? All this will be given. Generally, if a shareholder fails to pay the installment, that is calls money, company have a right to cancel his shares, which is called forfeiture of shares. So relating to that, buyback of shares. Sometimes companies buy the shares from the shareholders itself. So under what conditions company have a right to buy back? Conversion of shares into stocks means shares are individual units. Stock is a combined, a group, a lump sum amount, a number of shares or stock. We cannot divide them again, split them into small units. So alteration of share capital, like if a company wants to say registered capital, it wants to have a maximum of 10 crore capital, which is registered with the register. Now it wants to go higher or decrease. So it can make, right? depending on its business of profitability. So whatever it wants to do, when it can alter the capital, what are the legal formalities? That information also will be provided. Like that, many managerial aspects, dividends, what amount of dividends can be declared, what extent dividends can be declared, when. Okay, so when dividends can be declared by the company. All these will be discussed. Borrowing powers. What are the borrowing powers that the company has? To what extent the company can raise the funds? Who are what assets can be offered as a collateral security? All those are discussed under the borrowing powers of company. Accounts and auditing. What books of accounts are kept and maintained? When how it want to proceed with the auditing? Who are its auditors? All the general meetings. How many general meetings it is? Generally annual general meetings, and the topics they're going to discuss. Directors, who are the directors and what meetings they are going to conduct. Additional directors, if any, who are those additional directors, their names and addresses. Capitalization of reserves, if a company maintains any reserves, when it can convert them, capitalize them, what are the rules and regulations to be followed. Similarly, voting rights of the proxies and winding up, when a company can go for winding up. All these relating to the internal management of the business are conducted by the company and discussed in the company. Okay, so contents of articles of association. So, similarly, articles of association, like memorandum of association, will be prepared with a due care and consent. But sometimes certain things need to be changed. Sometimes certain rules and regulations need to be modified. Okay, such times. What are the rules and regulations to be followed? That again, whatever changes are made in the articles of association, every change has to be registered again with the registrar. Then registrar will verify and make the necessary changes in the register in their registered book. Okay, company's register. So that is the reason why alteration of articles of association also involves expensive. So they do very carefully, but when times require, they may go for alteration. Is not necessary. Coming to the difference between the articles of association and memorandum of association, object aspect, if you see, memorandum is a primary document which tells the scope of the activities of the company. Articles is a secondary document which tells about the rules and regulations for the internal management of the company. Nature, company relationship with the outsider world, it tells the bylaws for the internal management of company. Status, supreme document, and articles is a subordinate to the memorandum. Ultra vires, if a company ultra virus beyond powers. I think yesterday only I told ultra virus means beyond powers. Memorandum is means if a company act beyond the point specified in the memorandum, they will get a void, means they'll not be valid. Whole body of shareholders cannot ratify them. Okay, and what about these articles? Any act of the company which is ultra virus, the articles can be ratified by the shareholders. Company under articles in against the articles, rules and regulations against the articles of association of company acts, those can be altered or ratified by the shareholders. But if a memorandum against the memorandum of company acts, nobody can alter. It's a becomes a legal issue. The alteration of memorandum involves legal issues under certain conditions if required, with the central government permission and special resolutions, both together they may go for a alteration of memorandum of association, but articles of association need a special resolution. Any changes in the articles of association, that is alteration of articles, need a to be made with the special resolution. That's about these two documents. Do you have any doubts? And today I also want to complete prospectus. I'm going to share the one more. No, no. Second. So along with these two documents, list of directors. We are talking under incorporation of a company, right? For incorporation of a company, the company need to be registered with the so documents, the memorandum, articles. The third document to be submitted is list of directors. List of directors, number of directors of the company, and how many directors are going to be act under the name of under the company, and the written consent also has to be taken into consideration and to be submitted with the registrar. Okay, the next one is prospectus. After submission of these all documents, a company, the registrar of the companies will go through the document and its information and their legal requirements fulfilled or not. Okay, and if he satisfies, he will enter the company's name in a book called Register of Companies. Register of Companies. If it is a private limited company, in private limited companies list. If it is a public limited company, in public limited companies list, he will enter the book number, the name of the company, and he will issue the certificate of commencement, certificate of incorporation of a business. So once a certificate of incorporation of business is received, a private company will start its business and start its business activities. But a company, public limited company, has to wait for one more certificate called a certificate of commencement of business. So in order to get that certificate, first it need to raise its capital. Okay, so let us see how do it raise its capital. How do it raises its capital? Yes, prospectus is another important question you can expect in your examinations. So prospectus, what is a prospectus? A public limited company which wants to raise its capital from the public need to issue a prospectus. You might have come across the term prospectus when you go for admission. When you come to the study centers of BRAU also, you might have issued a prospectus, right? In that prospectus, you will be given all the information relating to the BRAU. Who are the director, who is the VC, who are the directors of various courses, how many courses it is offering, eligibility conditions, number of years, the academic years, the course duration, fees, examination, right? Same thing, a company's prospectus. Through the prospectus, a company invites the public to subscribe their shares and debentures, okay, in the form of shares and debentures. So prospectus is an invitation to public by which company invite the public to subscribe to shares and debentures, right? So for that, these public limited companies issue the prospectus. So private company will not issue any prospectus because they are raising their capital among themselves. So it will not issue any prospectus. Yes. Again, I need to again, this prospectus also is a document which is to call it as a document, it must be in writing, and there should be an invitation kind, and invitation must be to subscribe the company shares or debentures only, and this document should be dated, and prospectus is issued data on which the prospectus issued is considered as the date of publication of the prospectus. Okay, so let me this again here also. What I did in MS Office and then uploaded to my drive, so it changed everything. Okay, even this prospectus has to be signed by the proposed directors of the company. Okay, now let us see what is the information a company provides in its prospectus. Yes, this like name and address of the company, a name and address of the company, secretaries, auditors, directors, okay, and advisors, whoever are there. Opening date of the issue and closing date of the issue of shares. Name and address of underwriters of the company and how much amount that the underwriters have agreed to underwrite. Okay, and what is the procedure company adopting to allot the shares, and when it is going to make the allotment, and what is the company's capital structure, what is the nature of business, what is its minimum subscription, and who are the auditors, and what reports they are going to audit. Okay, what are its financial statements. Okay, then any other matters relating to the legal issues, how they are going to deal with them, and what is its legal jurisdiction under which the company is going to allot the shares, and issue of dividends on shares. Okay, all this information it provides through the prospectus to the uh, uh, okay. Next, regulatory authority of prospectus. Who regulates? Who regulates and controls? Look after the details of a prospectus are true and fair. So, the information regulatory authority of the prospectus is generally SEBI, Securities Exchange Board of India. Okay, the companies and these the companies which are listed under the stock exchange, which can be listed with which are listed with the stock exchange, all those companies prospectors are under the regulation and control of stock exchange board of India. Okay, all the matters relating to that are exercised by the SEBI. Now, the next and the last important topic, two more topics. With this, I'll wind up. Uh, Statement in lieu of prospectus. What does it mean by statement in lieu of prospectus? What did I say the prospectus means? Prospectus is the one which is, yes, you need to read all the points of maximum points under the contents of prospectus. Yeah. What is a statement in lieu of prospectus? Generally, a public limited company issue the prospectus of a company through which it invites the public to subscribe for the shares or debentures of the company, right? Okay, but sometimes even public limited companies wants to raise their capital privately, means from their private sources instead of collecting from the public. In such case, such public limited companies which raising their capital privately need not to issue any prospectus, but in the place of prospectus they are supposed to prepare a statement in lieu of prospectus. That heading itself only, that statement in lieu of prospectus means a statement in the place of prospectus. It means that. Okay, so this statement also contains all the information that has to be disclosed in the prospectus. Only the thing they prepare this and register with the registrar for allotment of registrar before allotment of shares and debentures to the private members. Okay, at least 3 days before the allotment of shares or debentures to the private members, they issue this and they register this with the registrar, because they need to register either it is a prospectus or statement in lieu of prospectus. Okay, but if it is a statement in lieu of prospectus, they need to register at least 3 days before the allotment. Okay, so it is only in the place of prospectus prepared when a public limited company raises capital privately, not from public. Yes. The next one is, so once capital is raised through the prospectus by the public limited company, the fourth step, the final step in the formation of a company, in case of public limited companies, is obtaining certificate of commencement of business. You can expect this in the short answers. Certificate of commencement of business in short answers you can expect. Even statement in lieu of prospectus, short answers you can expect. So what is certificate of commencement of? A private company, as we said, can start its business immediately after its incorporation, but public company only after raising the capital go for a certificate of commencement of business. So in order to get this certificate, a company has to file an application which is signed by the directors. And what are that information they're supposed to file? Stating that minimum subscription has been collected. Okay, and stating that minimum subscription has been collected, and no amount is due for the applicants, and all the directors purchased and obtained the shares of company, and all the provisions of Companies Act has been followed for the at the time of commencement of business. These four declarations are supposed to be provided. I think I gave that. I'm not finding that. Okay. So in the statement of yes. So in the in order to obtain the certificate of commencement of business, a public limited company has to submit 4 declarations. One declaration is that declaring that a minimum subscription amount has been raised and collected. Second declaration is that no amount is due to the applicants, or due or amount returned to the applicants. Third declaration is that all the directors stated in the list of directors document has been purchased and obtained the company, paid for the shares of the company. And the fourth declaration is that a company has followed all the provisions of Companies Act required to at the time of commencement of business. Declaration which is signed by the subscribers has to be given. So with these 4 declarations, a company will submit these 4 declarations to the Registrar of Companies. Then the Registrar of Companies will and pay some registration fee, will verify this and will issue a certificate called enter the company name in Public Limited Companies Register, and issue a certificate called Certificate of Commencement of Business. And once this certificate is obtained, a company is said to a public limited company can start its business. Okay, if a company fails to do that, it will be punishable. It will be punishable and liable to penalty of 50,000. So every company is supposed to pay. Get us every in the sense every public limited company is supposed to obtain certificate of commencement of business. Only after acquisition of this certificate, they can acquiring this certificate, they can go for starting the business, and they can enter into the contracts on behalf of the company. That's about joint stock companies. And next class, joint stock companies, incorporation of a joint stock companies, and commencement of business of about the important documents that we come under the joint stock company. Okay. Yeah. In today's class, under the joint stock companies, everything is important, children. Now, okay. What are all the joint stock company characteristics, types of companies, then incorporation of a company. Okay. These are the 3 essay questions, and memorandum of association, articles of association, prospectus. These all 5 essay questions which you can expect under in your examinations. Short questions like the difference between memorandum article can maybe long answer or short answer. Statement in lieu of prospectus, and then commencement of business. These you can expect under the short answers. Okay, right. Thank you, children. Thank you for being here. And in our our next class is on next Saturday. That is on 26th. Today it is 19, right? Next Saturday, that is on 26th. 26th, we are having our same time, 10 o'clock. PPT, 1 second. Formation of a company. Yesterday, I shared the PPT, formation of a company. Then what PPT you want? Today's PPT, memorandum of association. Actually, this format has been changed, children, and in this you also have the alteration of memorandum and articles, which is not necessary. You will get confused. So next class, I do that. Actually, I prepared separate for a BO. Next class, when we start, please remind me. I'll do that. Okay, I keep ready the links. Okay, next class, I'll do that. Right, thank you so much. It's a good number, but comparatively with the first class, the number of students joining is getting reduced. Don't do that. Keep in contact, listen to the classes, and in the class, whatever I'm taking the topics, all those are important. Please don't ask again and again about important questions. Attend, don't repeat. Okay, whatever we are discussing, because we are provided very limited classes, but the syllabus is vast. So whatever we are discussing in the class, all those are important only. Right. Thank you so much. Thank you. We'll meet on next Saturday.